Good morning, and welcome to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. I am located at 1563 Main Street in Peckville, and I'm here every Sunday from 8 to 9 a.m. on these stations to bring you valuable information that landowners need regarding natural gas development here in Pennsylvania. And at the Clark Law Firm, my focus is solely and exclusively on landowner representation, not gas companies, not pipeline companies, but solely dedicated and focused on representing Pennsylvania landowners and gas rights and mineral right holders. So today, I'm excited. I'm going to talk some more about this intro, but I just want to tell you, today I'm excited because one of the things, obviously, that I do in the office is negotiate and represent people in gas lease negotiations, gas lease reviews, and any and all matters relating to their gas lease, which may be in effect already, which maybe they've been presented with an offer. And I'm going to talk about some people who are receiving offers now to lease their property. And I'm going to go through some of these offers, and I think it's going to be very interesting for you. It's going to be especially interesting if you are currently, or if you currently have an offer pending in front of you. You're definitely going to want to stay tuned. But like I say, probably almost every week now, you know, what I do when I say, okay, let me get together, let me get some ideas. What am I going to talk about this week? And I look and I say, what's really kind of a hot topic that's facing landowners? What am I getting calls about? What am I getting new clients on? So I want to make sure that I'm staying up and we're giving you good quality information. So whether you're represented or need representation or are looking for representation, we want to make sure that you're thinking about the things that you need to be thinking about. So although I'm going to talk about gas leasing issues today, it doesn't solely relate to gas leasing, meaning that this same evaluation and these same concepts, as I often say, don't just apply to gas leasing in what we're talking about today, but also same concepts apply if you're looking at a pipeline agreement, if you have a surface use agreement, or essentially any other contract relating to gas development. Same thing should be popping through your mind. So although today's show I'm going to be talking about some gas lease offers that Pennsylvania landowners are currently faced or receiving, these same ideas, the same ideas of things you should be thinking about, the same kind of, I'll call them tricks, they're out there with other agreements as well. So we want to be aware of these things. You know, we want to be educated. We want you to be aware of these things. So although it's going to be a lot of discussion about gas lease, and I think this is very interesting. I don't care, even if you've already entered into a gas lease, I think you're going to find this interesting. Some parts maybe you might find troubling. So make sure you stay tuned because I'm kind of excited about today's show. I'm always excited to do the show, but this is something which is active, very active, and facing with landowners in Tioga County. But again, same ideas, same concepts apply no matter where you are in the state, things you should be thinking about. So I said again, I am Doug Clark of the Clark Law Firm. This is All Things Marcellus. I'm here every Sunday from 8 to 9 a.m. In my practice, I said I do gas leasing pipeline agreements. You know, I have, I don't know how many currently pending pipeline files, but I've done hundreds of pipeline, gas, and water line negotiations with over 40 and right around, I believe, 50 different companies in Pennsylvania to give you the idea of what's going on. And we're seeing a lot more of these eminent domain FERC lines, these bigger lines that are going to go not only within the state and gather gas, but going to transfer and transport gas to other states. And, you know, those are different type of lines. So I don't care what type of agreement you have, whether it be a pipeline, a lease agreement, a damage release, any of these agreements, you need to make sure that you're getting some quality assistance with somebody who's experienced and understands what they're doing. Whether it's me or anybody else, you need to make sure that you're getting this assistance. There's so many different reasons, and I know, most people, I always think back to my parents, they never had a lawyer for anything, I don't think, until the time that I left, and I think they did their wills even later on in life. They never had a need for a lawyer. They had bought a house when they were younger, before I was born, and they never had a need. So that's the same situation I think a lot of people are in that situation currently. And so now you get these contracts and you think, okay, well, do I need a lawyer? Why do I need a lawyer? I've never needed a lawyer. You didn't ask to be involved in this industrial development, but that's what we're dealing with here. And these are important matters that are affecting your property. And so, had this all not popped up, maybe you never would have needed a lawyer other than to do your will or a real estate transaction. But now, when you're given these contracts, you need to make sure that you're getting the assistance you need. It's two parts, well, there's several parts, but we always have the compensation. They're going to be paying you money typically for entering into an agreement. You want to make sure that you're taking full advantage of that opportunity. And then we also have the terms or the language of the agreement, and you want to make sure that you're doing the best you can to protect yourself and obtain the best terms in this agreement. And very, very rarely are you ever going to be offered the highest compensation and best terms that a company will provide to you whenever that landman comes out to you to offer you this agreement. So you really need to be doing this. You need to get experienced counsel to assist you. You need to be comfortable with that person. Whether it's me or somebody else, please make sure you're getting the assistance that you should be getting, because this is important. Now, I want to talk about, I've been doing the radio show since August of 2010, and you can check it out. Check out the websites. My website's at pagasleaseattorney.com and pipelineattorney.com. Great landowner information. Key is information, education. You want to make sure that it's credible, quality information. You don't want to just be relying on what you're reading on message boards, because you don't know who's writing that. It could be landmen for the company writing those messages. It could be somebody who maybe had a bad experience, which isn't typical, or somebody that had a good experience that isn't typical. So you want to make sure that you're getting quality, credible advice to assist you. So you can go to PA Gas Lease Attorney, go to Pipeline Attorney, go check out prior radio shows, check out issues that you should be thinking about, whether or not you're even looking for representation. You should be checking out, getting information. Also, we put the radio shows now up on YouTube, so you can go on YouTube, type in All Things Marcellus. You can check out the radio shows during the week. So if you can't tune in from 8 to 9 on Sunday, you can check them out also through the YouTube. But then also we're on iTunes. You can check out podcast section there. Type in All Things Marcellus on iTunes. And finally, if you are looking for assistance, you want more information, you can contact the office directly at 570-307-0702. Again, Doug Clark, this is All Things Marcellus, done with the intro. So let's go ahead and let's move on to what I'm talking about here today. Okay, so what we have, I'm going to talk about an offer. I've been getting calls from Tioga County from people who are getting offers to lease their property. Now, there's a lot going on in Tioga County right now, and what we see is we're seeing one offer, and I'm not going to focus on this today, but in one offer that's being presented to a lot of people out there in Tioga County is that they have leases which already exist, that they're already leased, and typically these people leased to a company called East Resources. East Resources then typically, in most cases, sold or assigned their leases to Shell, and now some of these leases have expired. Others are on the verge of expiring this fall, some into next spring, and some even into next year. And what's going on with these people is that Shell is going out and they have their landmen. They hire the land service company with landmen who then go out and they're presenting landowners with what's called a top lease, meaning a lease that would go on top of the existing lease and would not kick in or take effect until the existing lease expires. Now, if you're presented with this type of offer, you need to understand it. You need to speak with somebody. You need to get some more information, because you want to make sure that you're making the right decision for yourself. Now, the right decision for you may not be the right decision for your neighbor or your neighbor's friend or somebody else that you've heard about or somebody on a message board. You need to make the right decision for you. Now, what I'm going to talk about now, though, and I've talked about this Shell top leasing recently, I think in the last couple months in another show, but I don't want to make that the focus of today. What I want to focus on today is I'm getting several calls from other landowners in the Tioga County area who have been receiving offers from a new company that surfaced called Travis Peak Resources. LLC. That's Travis Peak Resources LLC. And because of, and we're very grateful, but because of the work we've done representing landowners in the past, we get a lot of calls when new offers come out. It's interesting. We're really excited about it. But all of a sudden, I start getting calls here at the office from landowners saying, hey, I got an offer from Travis Peak Resources. What do you know? Can you help me out? What should I do? Again, there's no set answer for anyone. What I'm going to talk about here today, as with every radio show I ever do, is never specific advice for a single individual. What it is information you should be thinking about. Hopefully it's going to be helpful. Hopefully it's going to educate you. It's going to get those wheels turning to say, okay, I need to be doing something about this. Or maybe I didn't think about this, and I should be thinking this way. So that's what we want to do. We want to get you thinking. We want to make sure that you understand if there are pitfalls or problems you should absolutely be aware of. We want to point those out to you. So again, I'm really excited about this because this is just a great example of an area where if you're just taking this contract and you're signing it, in my opinion, and I'm going to go ahead and be pretty general on this, or actually specific, I think you're making a big mistake. I really do. Here's what I mean. Okay, so I'm sitting here in front of me. I have two different landowners who sent me in their Travis Peak Resources offer. Now, Travis Peak Resources, I get this call. I said, well, geez, this is the first time that I've heard of this company. So then I go on and I do a little research, and when I say a little research, Google Travis Peak Resources LLC and come up with their website. And, look, it's what it is. You go, you look at a website, and you can go look at an Exxon, a Shell, a Chesapeake, a Cabot. Go look at some of the Southwestern, look at their website, and then go back and look at the website of, say, Travis Peak. And you can get an idea of, what type of company it is, and I'll allow you to make your own judgments. Well, one of the things that stands out to me is that the company, Travis Peak Resources, was actually formed or established in November 2013. So just established in November 2013, where several individuals with impressive gas experience in development, geology, other areas, come together and form this company and establish it in November 2013. Now, I'm going to tell you, I've seen this happen in the past and many times with different companies over the past, say, 5 years or more, where executives, geologists, people get together and form these new companies with new opportunities that are out there. And, look, I'm not judging on any of this. I want to make that clear. But I have seen in other cases where I've had clients who had offers from some of these new companies, and I'm not saying this, I can't stress this enough. This isn't about Travis Peak at this moment. This is about just being aware that you want to watch out when you have a new company. You want to make sure that you're comfortable if you're going to sign with them, and you want to make sure that this is something you really want to do, and you understand the potential issues that may arise. Again, may arise. Totally separate. 4 or 5 years ago, and this case always sticks out because it's actually a brother-in-law of a good friend of mine was representing him, and he had an offer from this company. It was a newly formed company with executives that came from very prominent companies in the industry, and he had a lease offer, and we worked on it for a very long time. And at the time, it was like $5,000 or $6,000 per acre, very high royalty rate. So ultimately, he decided he wanted to sign, and I had some reservations and concerns about this particular company, but he went ahead and he signed it. And about 3 or 4 months later, we got a notice back saying, hey, thanks, but no thanks. We're not going to go ahead and take this lease. Now, in this process, he may have missed out on some other opportunities that maybe not carried the same type of financial compensation he was offered by this company, but was a long-established company that maybe might have been a better choice for him. Again, I'm not saying this in this particular case. What I'm talking about is things that you need to be aware of. Okay, I'm going to really dive into this. I'm up against the break. And dive into this next segment. You're listening to All Things Marcellus with me, Attorney Doug Clark. I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm here every Sunday from 8 to 9 a.m. on these stations. And also, you can go check out YouTube. Type in All Things Marcellus. We put up today's show tomorrow. So you can have access, all during the week, and actually as long as it's up there on YouTube. So if you can't tune in every Sunday from 8 to 9 a.m., you can always go into YouTube, or make sure you check out, even if it's not for the show, go to pagasleaseattorney.com, pipelineattorney.com, sites dedicated to get you information, get you thinking about issues that you should be thinking about if you're involved at all in oil and gas production, or if you have any lease offers, pipeline offers, or any other type of offer from a gas company. But also estate planning issues, royalty issues, you're getting royalties. Check these sites out. I think you're going to find there's some valuable information for you out there. Okay, taking a step back, I gave an example at the end of that last segment about a gentleman who I represented several years ago who entered into a gas lease with a newly formed company, and ultimately, and for a lot of money, and this gentleman had several hundred acres, and to my knowledge, that's still never been leased. So because now there's no other lease offers, or hasn't been since this time due to the location of this property. But in any event, he had a very good lease offer. He entered into that lease offer. It was a newly formed company. By the time it came under the terms of the lease to be paid, that company said, thank you, but no thank you. Here's your lease back. We're not interested. I am not saying that same thing is going to occur. May never occur again ever. I'm not saying it's going to occur. I'm talking about Travis Peak Resources today. I'm absolutely not saying that they're going to do that. I have no idea. I'm just stating that something that occurred in the past is something to think about. It's always your decision, your comfort level. It absolutely may be right for you. It absolutely may be something that you feel is a spectacular offer. You should take advantage of it. I am not saying that you shouldn't. No specific advice. What I'm saying is you need to do your research and you need to be comfortable. Okay, so I've been getting these calls from Tioga County about lease offers for people whose leases are either expiring, also people who aren't leased in an area that they haven't received a lease offer, or maybe their lease already expired and now they're getting new offers. Now, many of these offers are coming in from Shell. I'm not going to talk about Shell today. What I'm going to talk about is another company that people are getting lease offers in Tioga County from, a company called Travis Peak Resources. And again, if you're tuned in and you say, well, geez, I'm not in Tioga County. I don't have a lease offer. My property's already leased. I think you're going to find there's still some very important information here in today's show that's going to be helpful for you. Even if you're considering a pipeline offer, this is very important. So let me get to it. Here we go. We have two different landowners who receive a letter from an individual, a landman, who is representing Travis Peak Resources in an attempt to secure leases in Tioga County in this area. So now what we have here is we have one letter to one landowner offering a general offer saying that we will offer you a 5-year primary term lease of $1,000 per acre and 13.5% gross royalties. I want to underline that, gross royalties. So one person who calls the office has a 5-year offer, $1,000 per acre, 13.5% what they're told to be gross royalties. Next individual, turning my head to the other offer sheet here, this individual was offered a 5-year plus a 5-year extension. They're offered that at $1,250 per acre and a gross royalty, again stating that it's a gross royalty, of 13.5%. So in this case here, we have a person who has if you wanted the option to extend or provide the company with an option to extend at $1,250, that you could have that option as well. Now, this first individual also has that same offer where they could have a 5-year deal at $1,250 plus a 5-year extension. However, the second individual, they didn't have presented to them the 5-year term at just a flat $1,000 and 13.5% royalties. So there's a slight difference there in what that initial offer is. Then we have both individuals were offered a 10-year lease in exchange, or instead of the initial offer here, they were offered a 10-year lease term as a second choice, a second option or a second choice. They could sign a lease for 10 years. there'd be no option to extend, and instead of the either $1,000 or $1,250 per acre bonus, if they signed up for 10 years, they would receive a $1,500 bonus. So, a little bit more money, $1,500, as opposed to if they did a 5-year lease that allowed for a 5-year extension, that offer would be $1,250 for each 5 years. So let me explain that. That's important. So the way this is set up is that if you took the option where you signed a 5-year lease and the company had a 5-year option to extend, if you signed a lease, you would be paid, assuming you're paid $1,250 per acre. At the end of 5 years, if nothing occurs and the lease isn't held by the terms of the lease, meaning they didn't do enough or didn't do something in order to hold this lease would then expire in 5 years. However, if the company were interested, they could pay the landowner another $1,250 to extend this lease for another 5 years. So in that case, if, and that's a big if the company decided that they wanted to extend the lease in 5 years and they didn't do anything, they would have to pay the landowner another $1,250. So the total payment there, if all of these things occurred, would be $1,250 to do the lease first for the first 5 years. If nothing happened, another $1,250 for a total of $2,500. Now, the 10-year option, what that does is it gives the landowner $1,500 up front, which would be, if it's paid, you get all of that money. So whether they do something in 5 years or not, so if they do something in year 2, you've got that $1,500. If you took the other option and you just did a 5-year lease with a 5-year option to extend by the company, if the company did something in year 2, 3, or 4, or even prior to the end of the 5th year, you would be held under the lease and you'd get no more payments. So some people may say, well, you know what, I'd rather have that extra $250, but you're signing on for 10 years. And that's a very long term. So to me, as a general rule, I get very nervous about 10-year leases. However, sometimes it may make sense if you think about this. If all the people around you have signed 5-year leases and their leases are going to expire, maybe they're in year 2, 3, or 4. Maybe we look around and we see there's all kinds of development around you. Well, maybe a 10-year lease actually makes sense because it's a way for you to get more money now, but it's going to happen where you can have reasonable expectations that you're going to see development much sooner than 10 years. So if we can look at it, and that's the situation we see in front of us, then if you're going to get extra money for a 10-year lease, and we're really confident as much as we can be that there's going to be development much sooner than 10 years, then in those cases, take the 10-year lease and take the money. But you have to look at your circumstances. Again, there's no general answer that applies to everybody. I am Attorney Doug Clark. You're listening to All Things Marcellus, and I'm here every Sunday from 8 to 9 a.m., and I want to talk now about this gross lease offer. And this is something, I've talked a lot about royalties. I'm very involved in these royalty situations with the companies. And this is something that drives me insane. It gets me so fired up where I see here this offer to the landowner saying, okay, we're going to pay you 13.5% gross royalties. Well, okay, maybe that's something you might be interested in. 12.5% is the state minimum. Generally speaking, I think I had one client since 2008 who signed for less than 15%. But that doesn't mean that that's not, that the market's not going to change and you may be in a position where you feel that that's in your best interest. And it very well may be. And so I'm not saying, again, that you don't do it. I'm saying just factually in my experience, I can only recall of one individual that I can think of that I've represented in the last, since 2008, who signed for less than 15%. So with that said, this is saying that it is a gross lease. Well, it drives me crazy because, as you know, if you listen to the show, different companies treat leases and lease language and royalty calculation language in different ways. Some companies are taking deductions for gathering and transportation under lease language, where other companies under the same identical lease language are not taking deductions. So it's tough to sit there and say that, hey, this is a gross lease, when we don't know, when the company develops your property, how are they going to interpret the language that you're presented. Now, with that said, there's language out there where companies, the vast majority of the companies, if you have certain language, they're generally not going to take deductions because it's pretty clear. But that language, ladies and gentlemen, is very rare. Very, very rare. So when I see this gross royalty language in this offer, I immediately dive to the royalty language and start reading to say, wow, this is neat. Let me see how they've written this, so they can make these representations that this is going to be a gross royalty. Well, sure enough, we dive into this, and it says here, and I'm not going to read every single sentence here, but it says royalties for gas and oil, 13.5% of the gross proceeds received for the gas sold and used off the premises of the actual amount received by the lessee or the company. Listen, when you start seeing actual amount received, be careful. To me, that's a bit of a warning sign. All monetary sums accruing to the lessor or landowner under this lease shall be without monetary deduction, directly or indirectly, for the cost of producing, gathering, storing, separating, treating, dehydrating, compressing, processing, transportation, and marketing the oil, gas, and other substances. All right. If you listen regularly, that's going to sound very familiar. Okay. We love that. We love that. Okay. You're going to pay us royalties without deduction, directly or indirectly, for the cost of producing, gathering, storing, separating, treating, dehydrating, compressing, processing, transporting, and marketing the oil and gas and other substance produced hereunder. That's great. But, big but. Okay, produced hereunder to transform the product into marketable form. To transform the product into marketable form. Then, so we got the marketable form language. Then it says, however, any such costs which result in enhancing the value of marketable oil or gas or other products to receive a better price may be deducted from lessor or landowner's share of production, so long as they are based on the company's actual costs of such enhancements. I actually want to throw this lease up in the air right now because this is the market enhancement clause. This is the market enhancement clause. This is the clause that Chesapeake and other companies say permits deductions because the gas is in marketable forms in many places of the state. Gas is in marketable form, they argue, at the wellhead. Okay? So they say when we transport it, when we gather it, we transport it, we move it, we are enhancing the value of gas which is marketable at the wellhead. That's the company's argument. So I can tell you this with certainty as I sit here today, that if Chesapeake was producing under this list or this lease, you would be having deductions. This would not be a gross lease. Now, Travis Peak Resources is the company on this lease. What do? Well, I'm going to tell you, they were established in November 2013. To my knowledge, they're not producing any gas anywhere. Maybe they are. I can't say that with 100% certainty. But I can tell you this, I'm completely unaware, and I don't believe that they're producing any gas in the state of Pennsylvania. I certainly don't believe that there's any gas being produced and people are getting royalty checks from Travis Peak Resources, and Travis Peak Resources is not taking deductions. To sit there and to say that this is a gross lease is very disturbing to me. I'm going to talk more about this. I'm way over my time. You're listening to All Things Marcellus with me, Attorney Doug Clark, here every Sunday from 8 to 9 a.m., and I'll be right back after this break. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. Again, I'm here every Sunday from 8 to 9 a.m. And if you miss any of today's show, check us out. You can go to pagasleaseattorney.com. We have the shows archived, 150 plus hours. We'll be closing in sometime here soon, I would hope. Well, I don't hope, but 200 hours or so, 175. We're doing the show, every week, got some reruns running in here, but been doing the show since August of 2014. And you can check out the show again, pagasleaseattorney.com, pipelineattorney.com. Also check out YouTube so you can get immediate access to the show. Right? We do put it up there on Monday morning. So we want to make sure that you're getting this information while it's current. All right, I'm talking about this Travis Peak Resources offer in Tioga County, and I'm talking a lot here now, and I want to continue on this because, I wasn't going to talk so much on this exact issue, but again, it gets me so fired up, and this is occurring with other companies. Many people are getting lease offers and being told this lease is a gross lease. Many people are being offered what is being told to them as being a gross lease. However, it may not be, and maybe it is, but maybe the company isn't going to treat it that way. And this is a wonderful example, but this isn't the only company doing this and representing it as a gross lease. Now, at the same time, I'm not saying that you wouldn't ultimately be paid royalties without deductions under this lease, but what I'm saying is that there are several companies in Pennsylvania that absolutely would take deductions from your royalties with this lease. And in fact, this is the prototypical provision where all this litigation is really stemming from. So what we have here is we have a lease offer, we have a cover letter written to landowners saying, hey, we're going to give you 13.5% royalty gross. Well, does that guarantee you that? And I don't know that it does. And why I say that is, and I read that royalty provision, this is the provision in the actual lease itself. I mean, what they've done here is they've put the market enhancement provision in the actual form lease. Now, I'm going to talk about that a little bit too. So think about this. Here we have a company, Travis Peak Resources, established in November of 2013. They're making a lot of offers here to Pennsylvania landowners at the present time. And what do we know about Travis Peak Resources? Again, we know they were established in November 2013. You can do some additional research. We know that when they're not involved in production at this time, and we question just legitimately, and they very well may. These are just questions. These aren't statements. And again, I'm not trying to beat these guys up. I don't know these guys, and maybe they may develop all of these leases and not take any deductions, and that's wonderful. And that would be absolutely wonderful. My concern is to make sure that people are thinking about certain issues. Not saying this is how it's going to be. I'm saying this is what you need to be thinking about. Because there are multiple companies that have this market enhancement clause, where they're taking deductions, and the biggest being Chesapeake. Now, the other thing is, so if you're a company and you're taking leases, and 13.5%, which is an interesting royalty number. Like I said before, the state minimum 12.5%. So 13.5%. One thing that we see companies do all the time, and especially I think it's more likely with smaller companies or newer companies, what we'll see is that company will take a lease from a landowner, and then they'll look to sell or assign that lease to a bigger company, a producer. So that's certainly a possibility that may occur here. I'm not saying it will. I don't know. But that's something you need to be thinking about. And what I mean by that is, 13.5%. That's interesting to me because a lot of companies, I said earlier, I haven't had many people, I have one person I can remember, since 2008 sign below 15%. So one thing that companies sometimes do, not saying Travis Peak does this, but something that companies sometimes do. They'll take a lease with the landowner. Let's just, for this example, use 13.5%. They take this lease with the landowner at 13.5%. Then they say, well, you know what? Either we don't have enough leases, or maybe we never really intended to develop this property and drill wells, but we wanted to get leases, and now we want to, often called flip, or sell or assign the leases we've acquired and sell them to another company. So think about this. If you have it 13.5%, let's say hypothetically We have Shell, pick a company, Southwestern. They're offering 15% in around the area where this lease is being taken. Well, now here you are as a company. If you can get 1,000 acres, couple thousand, whatever you can get, well, then you turn to this bigger producer company, or not even necessarily bigger, but a producing company. You say, hey, look, we have 1,000 acres. We have 2,000, 3, 4, 5,000 acres under lease. We'll sell or assign you these leases. In fact, we have these leased at 13.5%. What we want to do, though, is we'll sell you these. In exchange, we want to have, maybe some per acre money. So, maybe they want to, and again, I can't get into specifics. I'm just giving this example. But say they want, we'll sell you this, but we want $500 per acre for what we sell to you. Now, that's a possibility. Maybe it's $250, maybe it's $1,000, who knows. But there's a possibility of them selling or assigning this lease to a bigger company in exchange for a per acre bonus or payment for the amount of acreage they assign or transfer. Another thing that they can do, very common, they can get a royalty percentage. So, just to make this simple, say in my example that Shell or Southwestern is paying landowners or offering leases at 15%. Well, if I'm a company that takes leases at 13.5%, I can then say to Shell, Southwestern in this example, hey, I'll assign you these leases, this 1,000, 2, 3, 4, 5,000 acres of leases, and I know you're paying 15% royalty, so I'll still let you keep your 85%, or we'll strike a deal where you can still keep your 85% royalty. The landowner will get their 13.5%, but there's another 1.5% difference. The lease is at 13.5%. The big company, Southwestern or Shell, wants to pay out no more than 15%. So we give the landowner 13.5%, and the company who transfers all of these leases to the bigger company gets 1.5% royalty from all the acreage that they've transferred. That can be a really good deal. So maybe you can go out there and get 500 acres leased at 13.5%. Maybe if you leased it, say, at $1,000 per acre, maybe you can sell those leases or assign them to a bigger company and say, hey, how about giving me $1,500 per acre, because I'm going to give you all of these leases at one time and give you, in my example, 5,000 acres at once. So maybe that bigger company say, okay, we'll give you $1,500. So now the first company, just on a bonus alone, makes $500 per acre for what they've just sold and assigned. The landowner gets to keep the money they originally got, but they don't get any of this transaction. But that's okay because, as a landowner, you have to understand that this can occur when you originally enter your lease. Part 2, if I'm the company, I say, well, I have this acreage here. I got 5,000 acres I want to give to you, big company. So number 1, I'm going to get $500 per acre bonus for each acre I transfer to you. Overall, that'll be my net gain. But then also, I want to get some future royalty interest. So I'm going to give you these leases at 13.5% royalty. So the landowner will get, no matter what, get 13.5% royalty, but I want to have 1.5% royalty from everything that I transfer. So the gas company, the big company that's going to produce, says, okay, hey, we're going to get 85%. We're going to give the assignment company 1.5%. And we're going to give the landowner 13.5% because that's how it's written in their lease. So we're still the same. We would have given the landowner 15% in the example and kept 85%, but we don't care who gets the 15%. We just want to make sure that we meet our goal of 85%. So again, this is an example. I'm not saying that this happens in this case, but it's certainly possible. It's also possible Travis Peak takes these leases, goes out there, starts drilling wells, produces, give landowners 13.5% gross royalties. However, it's also possible that Travis Peak Resources could enter into this lease to the landowner, knock on Chesapeake's door and say, hey, Chesapeake got all these leases, like to assign it to you. And if Chesapeake were interested, not saying they would be, but they could take the leases, give Travis Peak certain compensation as far as just a cash payment, which may or may not be a windfall for Travis Peak. Then Chesapeake may say, okay, Travis Peak, I will give you 1.5% royalty from all the leases you transfer. We'll pay the landowner 13.5% royalty. However, Our position is that under this royalty clause, we're allowed to take deductions. So now this landowner who was told by Travis Peak in their offer that this is a gross royalty without deductions, if this were to occur this way, that landowner would have deductions being taken the way things are at the present time. Things can always change, but this is a real example. I mean, that's something that's certainly plausible. Again, I can't say it enough. I'm not saying it will occur that way, but it's certainly plausible. When you see or you're told that something is a gross lease offer, you really need to look at that language. You need to also look, when a company is making you an offer, you need to look how strong is that company? How active is that company? How many leases have they taken? Have they paid on prior past leases that they've taken? You need to look at that. Now, how many times I say it, it's up to you as a person and your comfort level. I'm not saying you don't do it. What I'm saying is some people may say, you know what? I don't know enough about this company. There's not enough background. I haven't seen them drill any wells. I'm concerned about the gross royalty. You know what? Maybe this isn't the offer for me. Now, other people may say, well, and understandably, hey, this is the first offer I've had in some time. Maybe I have 100 acres and I'm about to, if I sign this and they pay me, they give me $100,000. That can really change my life in a lot of very positive ways. I could really use $100,000. Maybe you have less acres. Maybe it's 50, maybe it's 20. But, most people can use additional money. And so maybe it makes sense for you. But you need to understand that if you're going to do that, are there potential problems? Are you aware of these potential problems? Have you thought about them? And if you're comfortable, go ahead and do it. But you need to be thinking about this. One thing that you have to watch out for as a possible consideration is, in my example before, a gentleman I represented years ago as a brother-in-law of a friend of mine, and he had a very high offer from a newly formed company. And they ended up, after he signed a lease, and we did all this work, went back and forth, and he signed a lease, and then they never paid on it. They said, you know what, thanks, but no thanks. So one of the things I look for when I deal with a new company is, what is their payment history? How many leases have they paid on? Obviously, have they developed any property? What are their intentions? Ask them, what are your intentions? What do you plan on doing? Now, they're typically not going to say, oh, well, we want to enter into a lease with you and then flip it to a bigger company and hope that we make financial consideration on a bonus type structure where we lease you at $1,000 or $1,250 but sell it to them for $1,500 per acre. And also, we also want to try to make some money on royalty by leasing you at 13.5% and selling it to the company where you'll get 13.5%, we'll get 1.5%, and that company will get 85%. So you need to be aware of that. Again, I'm not saying that that's what's going to occur here. I'm not saying that. But I'm saying certainly that's a possibility that could occur. So the other thing, I get these new offers, or I see these, I want to look at a lot of different things. One of the things that concerns me with the offers that I have here, none of the information is filled in. Not the landowners' names, not what's bounded or like what their neighbors are. All this there's a lot of blank spaces. They're just sent out this form. That makes me a little bit worried. Is the company just like fishing? I call it fishing. Throwing out your line, throwing out these letters to a ton of people and hope that you get some fish, get some bites. Some people bite on this and then you decide, okay, well then we'll follow through. Usually when a big company wants to come in and lease your property, when you get a lease form, that has all your name and has your name and information in there. Says what properties are bound to your properties, meaning what are next door, what are adjacent, has a lot of different information, has maybe your deed book, page number, has detailed information. That tells me that, hey, they're really serious. They've done some background work. So we want to watch that. Again, not saying that you don't do it. I'm saying that these are signs that make me a little bit nervous. I am Attorney Doug Clark. This is All Things Marcellus. I'm up against here the last break. I'll be right back after this break. Again, I'm here every Sunday from 8 to 9 a.m. on these stations. And again, I'll be back in one moment. Welcome back to All Things Marcellus with me, Attorney Doug Clark of the Clark Law Firm. And again, we're talking about a lease offer that I'm seeing a lot of landowners, or several, I shouldn't say a lot, several landowners being offered, and in particular in this case in Tioga County. I want to stress, and I want to make it very, very clear, I'm not saying the landowners should not enter into this offer. What I'm saying is, and I'm not saying that they should, what I'm saying is that they should understand these type of offers and really scrutinize not only this offer, but any offer you receive. I'm not saying that Travis Peak won't do exactly what they're saying they're going to do. I'm not saying that they won't go ahead and develop the property, pay you a gross royalty, and not take any deductions. However, I am saying that there's the possibility that it may not work out that way. And I've seen in the past things where in similar situations, they not work out the way in which landowners think they might. So I want to stress that. And most importantly, it's thinking about, is this the offer for you? And maybe it might be the offer for you, but maybe it isn't the offer for everybody. One of the other things I say, look, there's no perfect offer. And if you're sitting out there and you say, well, all right, they're telling me this is a gross royalty, but they're offering me what we call the market enhancement clause. And we know that several companies are taking deductions under the market enhancement clause. So if we understand that that may occur, if we understand that even though we're told that it's gross, it may not actually end up being a gross royalty, but we don't have any other offers. We've been waiting for offers, and we're willing to assume and to take on that risk that maybe there might be deductions, but we are offered $1,000 or $1,250 per acre. We're aware, we understand, and we think that this is the right decision for us. Well, then there you go. You've had a good evaluation. Now, it's not just over there. You need to look at other items as well. One of the other things that I often look at whenever I see some of these, maybe a smaller company or a newly formed company, we want to look at how quickly are they going to pay you under your lease. Is this something that they're going to pay you within 90 days? Is it going to be 120 days, 60 days? How long is it going to be? Now, another good thing there, another interesting thing is maybe that's an area you really want to push back on and say, hey, instead of paying me in 90 or 120 days, how about paying us in 60 days? I like that idea a lot, because then we can see, will the company expedite the payment? Now, another thing you always need to be aware of is that whether it's a 90 or 120 day pay term, and in this case, in the agreements that I was provided in this case, they're 120 days, which to me is a bit long. We'd like to see typically no more than 90. So it's 120 days to pay, but in almost all leases, if you're not paid in 120 days, they have what's called a cure period, meaning that if you don't get paid in 120 days or 4 months, then you have to write a letter and say, hey, company, you haven't paid me. The lease said you're supposed to pay me in 120 days. And normally they'll have 60 days, sometimes 90, sometimes 30, but normally it's another 60 days to go ahead and pay you. Now, it's very important to you look at that. So a 4-month pay term can become a 6-month pay term. And if you don't write them and tell them, hey, you forgot to pay me or you didn't pay me, well, once you do write them, they have 2 months. So if you wait a month, they have 2 more months. Now, does this give a company the opportunity to sit back and try to market or sell these leases or sell your lease to a bigger company? Well, yeah, it can do that. And maybe they find out, what? We committed that if we accepted this lease, we had to pay the landowner $1,000 or $1,250 per acre. We can't find any company that's interested in taking the lease. We don't want to pay this guy because we're not sure that anyone's ever going to develop it or we're going to develop it. So it gives us this window to market the lease to a bigger company, to package leases together to market them. And if we can't sell them, then we have a decision to make. We'll either pay on the lease or not pay on the lease. And I talked about that case earlier. That's what we saw. Now, I can't tell you what happened all behind the scenes, but the client landowner entered into the lease with the newly formed company. Again, not Travis Peak, and not saying Travis Peak does this or would do this. But in this case, this company, told me everything I wanted to hear about their commitment to drill and how serious they were and all these different things. And then ultimately decided that they weren't going to pay in the lease. And their reasoning was, well, we didn't get enough acres that we felt that we could develop. So you need to understand that. Now, the problem or concern is during this 4-month period and possibly longer period, well, maybe there are other legitimate offers that may come up. Maybe a producer will offer you 15% royalty. And if you're under this lease and the other company says, you know what, the producer's going to offer us 15% royalty, so we're going to sell your lease to the producing company. We're going to keep some royalty interest because if the company's offering 15%, we can get 1.5%, and you're going to get 13.5%. So we're really going to make out on this deal as long as it's produced. So that's something that's a real potential being out there. You need to be thinking about these issues. Maybe it's still right for you. Maybe you want to move forward. You understand all the risks. You understand the concerns, but you decide you want to move forward. Hey, that's great, but you have to understand your circumstances. You need to understand what you're agreeing to and what the potential result is going to be. I am Attorney Doug Clark. This is All Things Marcellus, here every Sunday from 8 to 9 a.m. Now I'm going to jump to, so we talked about these, which are very critical points, things to be thinking about. Not telling you which direction this is going. What I'm telling you is if you get this offer, I think you need to get some assistance. I think you need to think these through. I think you need to ask questions, and I think you need to make I know that you need to make the right decision based on your circumstances. Now, another thing, I talk all the time about the value of experience. Well, in both of these offers, the landowner who sent me their offers had the lease offer and then also some addendum terms. So again, landman comes out, landman sends a letter. He gives you a lease offer and he gives you addendum terms. Well, in the one case, and I say this all the time, and I cannot say it enough, but it's not about the number of addendum that are added to your agreement. It's about the quality, not simply the quantity. But for illustration purposes, the one offer has a total of 6 addendum terms. One addendum term says that the addendum controls if there's any conflict. One talks about location approval, and that's actually a good term because this is a mutual consent on location. Not the greatest, but often the best you can get. Another is a hold harmless or indemnification. That's a nice term. You need to have that term. The other is no storage rights, which typically is something they're not going to do anyway. Then no disposal wells, which again is typically something that we always want to have in there, but the company typically isn't going to want to do. And the last one is reclamation, which the company is going to have to do anyway. So that's one offer that one of the clients sent me. Those were the terms. So there's one that had some real teeth to it, indemnification, which should be standard. And the other ones, we want to have them, but are they really going to make an enormous difference? So in the other lease offer, this guy who sends me his lease, he has, from the same company, 19 addendum terms. 19. So we go from 2, 4, 6 to 19. In these 19 now, how many of these are really valuable? Well, one of the things that point out is there's a location provision here as well. But in this location, it talks about that the company has to consult with the surface owner and try to minimize interference with the land. Well, that's not as good as mutual consent not to be unreasonably withheld, meaning that they would have to consult with you, they'd have to get you to sign off, but you couldn't be unreasonable. That's a better term. So this guy thinks, oh, wow, I got 19 terms. I'm in great shape. Well, the consent term, which is an important term, isn't as good as the guy with 6. However, there's other terms in here. Now, one of the terms that this gentleman has is a term that requires a $15,000 payment for any well site on the property. That isn't in the other agreement. The point being is that people were still offered different agreements and different terms. So what you do, if you have somebody with an experience, you have somebody that's looking at these, you have somebody that's helped other people in the past, you say, okay, I know this company will offer these 19 addendums in certain cases. I know that they also offer different addendums in other cases. Let's go ahead and put the best thing we can together and make sure we're maximizing your circumstance. We also saw earlier there was a slight difference in some of the financial and lease term offers. Slight difference as far as what options were. So we want to make sure that the landowner has all of the different options available. So we want to maximize compensation and we want to maximize the addendum terms and the language in those terms. So when you explore and you decide, hey, you know what, I think I want to do this. Well, now we have to turn the page to make sure that you're getting all the best terms that are available. Mutual consent could be the difference of having that well in your backyard, looking at it every day the rest of your life, or having it in the back corner of the property. Could be the difference. Not necessarily, but could be. You need to maximize. Also, $15,000 compensation for a well site versus crops and timber, which could be next to nothing. Very important terms. All right, I'm up against it. Hopefully you got the idea. A lot of different people still being offered different offers. You need to get assistance. I am Attorney Doug Clark. This is All Things Marcellus here every Sunday from 8 to 9 a.m. Have a great week, everyone.